Right, here we are, third time of the day today. I think this is probably my third or fourth live stream. Basically become the life of a streamer today. This is what it's like to full-time stream, I guess. And, I'm loving it. I'm loving it. I am a little bit tired, but hey, you know, it happens. But we have to continue here and stream. I appreciate everybody coming over and watching the Bryan Kohberger stream. As you know, we've been covering the situation in Maine. We did a follow-up this morning. We went into this afternoon and did a Bryan Kohberger update, reading the live tweets from Brian Enton in Court TV. And we revisited the active shooter Robert Card situation in Lewiston, Maine. And now we're bounced over here. Kohberger's 4 streams today, and we're going to do a little bit of an after show. So after show, I'll give some updates. I have some things going on that I want to update with all the members and let them hear some secret information that's going on behind the scenes. I'll update them some cases. I'm not going to waste too much time here because I want to get this 45-minute, 45-minute motion out of the way. I'm probably just going to sit back, not really commentate that much. I want to hear the full hearing. But I do want to say that I thought it was a beatdown and a slap today by Judge, and it's just my opinion and all of that. And I just think that the most hilarious thing of the day through all this was reading this tweet from Court TV, and it says, "Judge denies motion. I appreciate the argument, appreciate the journey back through history. What it comes down to me is that I'm constrained by what I believe is settled law. This is an issue you would have to bring to a higher court, the Idaho Supreme Court. Looking forward to you getting this settled." And then it goes on to say, hearing over, hearing over. And I just love that journey back through history, the journey back through history. And I almost felt like that was a little bit of a poke at Ann Taylor, knowing that in one of her recent motions, she had cited case law from about 100 years ago. So this is, to me, Judge responding. He is tired of the antics. He is tired of the shenanigans. He's tired of the tomfoolery. He is tired of the what other weird ones can I get in there? The can I get them all in? The tomfoolery. What's another one? But I think you're getting my point. We want to move on with this trial. The judge feels, in my opinion, that there is enough evidence to get this to trial. It should go to trial. Let's get this out of the way. And hopefully we get that announcement. Yes, the hooligans, and just getting tired of this. I did say shenanigans and tomfoolery. It's time to get on with this trial. So let's not waste too much time. Let's hear the hearing today, and then we'll get over to the after show and hang out. I have some updates for everybody here, but here we go. I'm just going to pretty much sit back, let this play out. Let's listen. The audible is, of course, horrible, but we'll do our best. All right, here we go. Hearing from today, Bryan Kohberger's motion denied. Let's go.
Be seated. Thank you. We're now on the record. This is the state of Idaho versus Bryan Kohberger. Case number CR 29222805.
Fucking audio.
You have that adjusted properly.
Every time we have an audio issue, I want everybody to throw up what can we throw up in the, is it an ear? Is there an ear emoji? There's an ear emoji. When we have an audio issue, I want to see some ear emojis. Let's play a little bit of a game here. We'll have a little fun tonight. If we think there's an audio issue, let's throw some ear emojis up. And I'll start the ear emoji. The ear emoji. Do we have an ear? Is there an ear? Yes, there's an ear. I love it. Already audio issue. Already an audio issue. Let's see the ears. Let's see the ear emojis. All right, let's keep playing this.
Okay, great. Couple of things I just want to share. Number one, I apologize for the delay. We were supposed to start at 1 o'clock. The hearing that started at 9:30 went a little long, but it was important. You're probably wondering why it was sealed compared to this part of the hearing, and that is because we were dealing with the procedure of the grand jury, the procedures of the grand jury, and there were a lot of details, and the grand jury is secret. So that's why it's sealed, and whether you like it or not, it's baked into our United States Constitution and the Idaho Constitution. So there's a reason for that. I want to
Yes, that's very true. That's very true, Diane.
People not to turn on the cameras until I was on the record, and they turn off when the record is off.
You'll be showing up.
Remind you, you just heard
You won't be showing
Matt
up.
talk to you about
It won't be here.
not having your phones, your laptops to film anything, to
bow out and be quiet.
record anything. That would be a violation of the rules, and we will take away your laptop or your phone. Some of these rules have been violated in some of our hearings, and I have an obligation to put a stop to that. And I'm sure you're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint. And some of that I've heard or seen has been disappointing. Just so you know, yesterday I issued an order addressing IgG DNA, and there's going to be an order for in-camera review that I'm going to go through. In-camera does not mean anything about a camera. That just means I look at the information before I can share it with the defense. You see, what else did I want to kind of share with everybody? I think that's about it. So we're here now on the defense motion to dismiss indictment on grounds of error in grand jury instructions or in the alternative remand for preliminary hearing. So Mr. Logston, I believe, is going to present the argument. Thank you.
Hey, Gar. Well, as Your Honor is aware, I wrote a lengthy brief or two on the subject of where we're supposed to be legally with our grand juries and where we actually are. And as Your Honor let me know this morning, probably not going to change your mind because the Idaho Supreme Court has, I think the court thinks, gone the other way. So I guess I would accept that kind of ruling as long as the court agrees with everything else that happens.
Well,
But
I don't know about that.
assuming that you don't, let's, I guess, just kind of walk through the simple steps here. So At issue in this particular case is Idaho Code 19-1107. And the infamous language in it that says that grand jury ought to find indictments and all evidence before them taken together, unexplained or contradicted, would in their judgment warrant a conviction by a charge. And the first question that a court has to ask is, what does that mean? And you start with the plain language, which we argue what warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when they had these on their books from back in the 50s, had already a case in 1962 where they said that it's clearly something more than probable cause, but they weren't too specific about exactly what it meant. And the state has pointed out that if you look at really old dictionaries, it looks like the word warrant means what you might think it does to old-timey folks, as it does to us, that if it warrants doing something, it means that it would permit doing something. So the plain language seems to support what we're saying. And the biggest problem that I have then is just that obviously everyone in the country disagrees with me, from sea to shining sea. And so I'm now put in the position of trying to explain why that occurred and why in the year of our Lord 2023, we are suddenly finding out that that's not quite how things are supposed to be. Why did we forget that we passed all these laws? And I don't have a great answer for that, other than I think the only time I ever heard about field codes before I was looking into this was like a really short moment in a class that I took back in law school. So, I mean, it's somewhat famously kind of the first attempt to codify the law of the day. It takes place in New York and spreads across the country back in 1850. And I think what I read in the tea leaves from the New York decisions and the later California decisions is that there was pushback at some of the things that the field code was trying to do. And one of the things the field code very openly said it was trying to do was fix the grand jury system. Because the grand jury system is believed to be essentially broken. For a lot of the same reasons we don't seem to like grand juries very much today. It was essentially believed that grand juries were hard to control. Grand juries essentially always favor whatever it is they were told and would always be accused.
This is great.
So, as a system to protect people, it didn't seem very protective. And they pointed out in
Bing, bing,
Bill
bong,
Code,
bong,
go back
bing,
and read
bing,
it,
bing.
that essentially the secrecy aspect of the grand jury is both its most powerful.
Look at Judge's face. I can't zoom in. I wish I could zoom in. Look at his face right here. He's like, what the fuck, man? Look at his face. Look at. He's like, I cannot believe. And Thompson's like, what the fuck are you talking about, man? Every time we get a date, I'm just going to play this tone.
Bing, bing, bong, bong, bing, bing, bing.
Oh my God. All right, let's keep playing here.
Sword and its kind of its worst aspect at the same time, because you just don't know what you're going to get out of it. And so they create a bunch of statutes that
When he
start
read the
to rein
tea,
in
I
what
can't believe he
grand
said
juries
that.
can and can't do. And they create some scenarios under which grand juries can be reviewed. And they, in the New York, they call it their Court of Appeals, but it's their Supreme Court, says, even though we have these statutes that say we should only set aside these indictments into these particular moments, clearly there's got to be some sort of a due process protection. If you're going to pass a bunch of statutes that rein in a grand jury, and if you can show that somebody's not following those to the prejudice of the accused, then that's going to work for dismissal as well. And that doesn't seem to be very controversial. We see similar language in that Gaspar case that we talked about in the state of Idaho, which I think dates to like 1913 or something along those lines, But at the same time, while the state of New York is trying to figure out ways to not have to abide by the language of what would warrant a conviction, by essentially saying, you can tell the grand jury that is their burden, but you can also tell them the probable cause thing, as long as they hear both of it, it doesn't really matter. And then the state of Idaho says, well, that's not even what that means, without any additional explanation for what they're talking about. And California apparently just kind of forgets about it until sometime after they've already passed a law in the 40s that says you can only dismiss a grand jury indictment if you can show that there wasn't probable cause. That kind of moots the whole situation that they've obviously fixed by statute. Our situation is such that we have this thing on the books, and the only group that seems to really dislike it is our Supreme Court, who keep having these opinions where they're like, please, prosecutors, stop telling people it's beyond reasonable doubt. This happens in the early 1900s, and it continues until the 80s, and they finally say, look, we passed a rule. I hope it's clear now. Stop saying
Bing,
that
bing,
your burden
bong,
is
bong,
beyond
bing, bing, bing.
Well, as the court knows, the way that those rules get created is a bunch of people that get invited to parties, unlike me, in the legal community go and are selected to sit in a room, decide what those rules should say. And there's quite a bit of the time it seems like the Supreme Court will later have an opinion and go, this is weird, why is this one of our rules? And so to simply say that, well, because the Supreme Court wrote it, that's their opinion on the matter isn't quite accurate. But clearly, the Edmonton court was behind that as a concept. At the same time, nobody was
Bing,
arguing.
bing, bong, bong, bing, bing, bing.
Nobody argued about it, the issue, until just now. Well, that's not quite accurate. Obviously, Mr. Orozco raised this in a few district court cases up in Green County. But nobody's really been digging into this or raising it until this time. So when the court says, look, the Supreme Court's already got a rule on this, Supreme Court's already ruled on it, it's just not true. They have never ruled that probable cause is the basis because there was an argument about it. And they said, no, you're wrong, it's probable cause. That hasn't occurred. They ruled a lot of things, but that's not one of the ones. And the fact that they adopted a rule that says something that they believed doesn't necessarily set in stone what the law is, or for that matter, what the Constitution has to say about it. So the big issue, I think, at least my favorite issue here, was can the Idaho Supreme Court override the legislature and lower the burden of proof for the county? And that was a tricky one because we don't really have a case that just comes out and says that the burden, or for that matter, I guess I don't know, we got this all kind of mixed up when we were doing the argument. So the burden of proof, I think we decided was actually who has to show something, and then it was the standard of proof is the amount that has to be shown. But everybody confuses it all the time, and I'm confusing it right now as well. But I'll call it the standard of proof just to be less confusing. In any case, the standard of proof is that something that the judiciary has power over? In other words, is that simply a procedural rule, or is it a substantive rule of law that courts can't mess around with? And we argued, it cannot be that if the Supreme Court woke up tomorrow and declared that the standard of proof in our cases was something beyond reasonable doubt in trial cases, that we would also say, oh, well, that's what the courts get to do. Because if you read those cases, what they talk about is that is a right, a due process right, essentially, of the accused that is set by the Constitution, right? That's what In re Winship is. It set the standard via the Constitution, locking.
Asking if the family members were in court. It seems like on their page, the Gonzalez family page, they were there. Said, court today, please pray for things are decided in our favor. We can barely breathe. We have been waiting for this day since September 20th. So it does look like they most likely were there at court today. All right, let's keep playing through this.
The standard of proof that's required for a conviction.
I know that they said they were
So,
going to be there.
when we talk about these standards of proof, it is true, obviously, that if you look
Not
at
a
case law,
problem.
you'll see courts setting a standard of proof for their own evidentiary rules. But you don't see it in many other places. What you see them doing instead is having somebody come in and say, well, the legislature set this standard of proof, but we think you should make it higher or lower based on, and almost nobody ever says lower is always higher. And we're always arguing that the Constitution clearly must set it in at some higher point to protect people, and then the courts lean in and say, well, we don't see any particular reason why the legislature messed this up, or if you're in the United States Supreme Court, occasionally you say, well, we do think that this is goofy and we're going to raise it. Okay? I couldn't find a case where the Supreme Court or anybody else leaned in and said, we think that the legislature is being a little too protective of its people here, and we're going to move down to standard proof for the government in this particular case, or one party versus the other. Typically, in this country, we try to protect the accused, and we believe that those protections are given to us via the Constitution and via these concepts of due process that come to us with common law, which is where this gets so messy, because the common law would tell you that it's probable cause, and it's some guy named Field in New York telling you that it should be something else. Well, we could get into all of that, but it would be, I think, more philosophical than anything else, because the state of Idaho didn't do it that way. The state of Idaho, as a territory, adopts.
I'm just going to pause real quick. If you all can do me a favor, we're going to have almost about 100 people in here. If you haven't already and you're in the room, please smash that like button. Let's try to get this up to 100 likes. We try to get that to every stream. Smash that like button, please. We can get 40 more likes in here. We'll get close to our goal of 100. I really would appreciate it. All right, let's keep playing through here.
The codes out of California, a code that they've already looked at, a code that they've already said, these words clearly mean something more than probable cause. This is what you're adopting. If you come and get it, the state of Idaho goes and gets it and adopts it. So that's what the state of Idaho is adopting. I obviously recognize that the founders that wrote the Constitution did not appear to recognize what was already on the books in this regard. However, just because they didn't recognize that doesn't mean it's not still part and parcel of what was thought to be true by a large portion of the citizenry of Idaho, who are the actuals who ratified the document. The only thing we know is that from 1890 to Edmondson, the Supreme Court of Idaho is repeatedly admonishing prosecutors to stop using a beyond a reasonable doubt standard for a grand jury. And that, it seems to me, is pointing to this concept. And if we're going to talk about common practice, the common practice looks to have been that everybody thought that the standard for the grand jury was beyond a reasonable doubt. And I don't think this is like worthy of the grave nightmares that I've been reading about. Obviously, in each one of those cases, the prosecutor was able to pull it off. And little wonder, I mean, it's still a grand jury proceeding. It's still just the prosecutor in a room with 16 citizens, 12 of which have to agree. They get control over basically everything that's being put on. I mean, the guardrails being put in, hey, let's use admissible evidence. Hey, let's not pull in hearsay witnesses. That kind of thing is not going to somehow make this impossible and make it so that it can't possibly work. What it's intended to do is just make it so that if you're in a position to get an indictment against somebody, you're going to put on your A game. But obviously, we've been talking a bit about how we don't think that that's what occurred in this particular case. And we certainly don't think that if the court were to adopt this in this particular case, that this would even remotely cut the mustard, because we know from the grand jurors that at least 6.
Did you just say cut the mustard? He said cut the mustard. That's great tomfoolery and shenanigans. He said cut the mustard. He said cut the mustard. They're cutting the mustard. Did you hear that? Let's go back and hear that again. He said cut the mustard.
I don't think that if the court were to adopt this in this particular case, that this would even remotely cut the mustard because we know
They say
from the grand jurors that at least 6 of them wanted to hear more until they were essentially cut off and told probable cause is the standard and what are you people doing?
You probably should cut that, what the grand jurors did or didn't do.
Ooh.
Fair enough, good.
Whoa. Dun, 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 dun. Judge poking back. He's tired of this. Whoa. That was a that was a slap. Did you hear that? Let's go back. He said you probably shouldn't talk about what the grand jury did or didn't do. So let's cut that. Oh, beat down. Whoopsh.
Because we know from the grand jurors that at least 6 of them wanted to hear more until they were essentially cut off and told probable cause is the standard and what are you people doing?
You probably should cut that, what the grand jurors did or didn't do.
Fair enough, good. But I'm just pointing out that there's clearly prejudice in the record that the court can see from what they want being instructed. It's also
Smash,
as we argue,
smash,
clearly when you
smash.
find out there, you tell the grand jury that this is the standard and it's actually something else. You can't possibly think that the result that you're getting is the accurate one, and so you have to do it again. These are fundamental rights that people have, so clearly that would be the way.
Right, but you just agreed that the court and the case law, going back to at least Edmondson, have the standard as probable cause. So, to just say, well, they were given the wrong instruction is not exactly the case. I mean, that is the standard that has been used in Idaho for years, maybe 100 years. It was different. It was different there for a period of time, but after Edmondson, I thought that it was pretty much settled. Now I understand the argument between substantive and procedural, and that's that can be a legitimate argument, but I'm not sure it's fair to just say, well, they were given the wrong instructions if everybody's using that instruction throughout the state.
He literally just undressed him, like just beat him. He just beat him. Oh my God. What is going on, man? Look at the smile on his face. He just totally whipped him. Oh man. What a beatdown. What a beatdown.
How dare you?
Oh.
Come on, man.
Smash, smash, smash.
Well, Your Honor, if that were true, then I'm not really sure what I'm doing with my life because I've spent much of it arguing that things that everyone in the state is doing are wrong.
Finish.
True.
And
Whoa.
occasionally, rarely, but occasionally, somebody says, no, that guy's right, and my client walks out of prison. So I'm
Well, that's fine. You can make an argument.
Look at the court
that
officer. He's smiling. Look at the court officer. He's smiling. Even the court officer is fucking smiling. They're loving this shit right now. The court officer is like, am I fucking hearing this right now? Am I fucking hearing this right now? Look at the smile on his face. This guy's like, am I fucking hearing this right now? Oh, I'm so glad we did this stream. This is fantastic.
something should
Look at the
change.
court officer. He's fucking
But
smiling.
are you telling me that other places in the state are giving a different instruction that it should be beyond a reasonable doubt?
What I'm telling the court is that it appears that up until 1980, that was true. And so the Supreme Court enters its rule, sort of has this
Ann
ruling
Taylor.
that talks about
Ann
that.
Taylor's body language is defeated. Look at her. She's like, oh fuck. And Thompson just like, yeah, keep going on, motherfucker. Yep. And look at this. Look at the other attorney here. He's like, yeah, just keep digging your hole, dude. Just keep digging your hole, bro. Oh shit.
But nobody's arguing about it because they don't have access to the internet. And nobody
That's
has a
what I
copy
wanted
of
to
the
see.
field
Took him to the woodshed.
or what California
That's
was
what I
up
was
to.
thinking of.
Oh, Justin Weissline
Look at
argued about it.
Thompson and this other attorney's fucking loving this right now. And the fucking court reporter's just smiling. I'm gonna back this up.
But nobody's arguing about it because they don't have access to the internet. And nobody has a copy of the field code or what California was up to.
Oh, Justin Weissline argued about it in a dissent in Edmondson.
And we thank him for it, although.
Okay.
If
You
you
can't
go
say
back
that there hasn't been an
Yeah.
argument about it.
Well. No. If you go back and you read what Justice Weissline did, Justice Weissline didn't know about the field code.
Bing, bing, bong,
He
bong.
knew it came out of California. He knew that it meant something different.
Oh,
I think
Well,
it's
that-
attached on the dissent.
That's
Some of that.
No,
Oh,
California.
those are earlier. Oh, those are that's the earlier session.
He has the California code and he has the stuff from the territories. That's what he's got. But he doesn't know. I mean, if you read the field code, which apparently nobody did, except, Justice Field in California. If you read it, it literally tells you what it's trying to do. It spells it right out. And you can find it for free on Google Books, which is where I got it. I don't have a copy. I'm not even sure where you find it, but it's
Look
on
at
Google Books.
Thompson. He's
You
like
can
reading
find
this shit right
and
now.
They had a whole preamble.
Ann Taylor's so defeated.
How
Ann Taylor is so fucking defeated right now. Look at her body language. She wants to get up and run out of this fucking courtroom. And Kohberger is just like, yeah, keep going, motherfucker. Yep, you're getting them. Oh my God. Look at the court reporters even laughing.
they're trying to
The
save the
court-
concept of grand jury.
Court
We want it to be better than what it is. We understand people have concerns about it. Let's make it better. And it gets adopted in California, and then we took it from that. And then that's what I think should matter. And the fact that the plain language of the statute is being read by every prosecutor in the state up into the 80s when the Supreme Court finally gets them to stop, because the statute's relatively clear. And so the only person who's pushing back against this are these Idaho Supreme Court justices who don't like it. But there's nobody coming to them and saying, here's a copy of the field code, this is where this all comes from, this was the point. Instead, there's just this concern that who could possibly want such a thing? How would we be safe if our communities are only able to indict people beyond reasonable doubt? It's just too much. It's too high a stake. That's hard to believe given how many of these cases are making it up because they were convicted. There's no reports anywhere that I was able to find that in the state of Idaho, all these prosecutors were mistakenly using beyond a reasonable doubt. There's just like no indictments going on. Nobody was going to prison. Nobody was getting the death penalty. It was a free for all, and we had posses riding around and having to deliver justice because the standard was too high at the grand jury proceeding. But that's not what was occurring. What you had was a perfectly well-running system that you had Supreme Court justices that were not aware of where this stuff was coming from. If somebody had come to them and said it, we'd have a ruling on it. But nobody did. In fact, we don't have really any state that's ever done the heavy work of this. You've got the New York Court of Appeals is about the only one that was aware because it happened there. And they've kind of let it drain away over time. Well, other states can do what they want. They can pass new statutes. Their constitutions are older than ours, etc. Our Constitution was written in 1890. So it's going to lock in what the people thought that they had as their
Bing,
law.
bing, bong,
what
bong,
they considered
bing,
to be
bing.
their standard of due process at that time. And the only history we have is you've got a Supreme Court saying, you don't have that right. You got a bunch of prosecutors, of all people, thinking that we can. And that's what you're looking at. The fact that the rest of the country is off doing other things, I don't think necessarily.
You think Kohberger's sitting there like, this is the fucking defense I got? This is really what they're gonna throw out there? He's probably fucking boiling inside right now. You think he is? You think he's boiling inside? Like, what the fuck, man? Yes. That's a perfect representation. I was just thinking like fucking People's Court. I'm picturing this guy in People's Court complaining to Doug Levinon in the hallway. 100%, bro. 100%.
It matters in terms of the courts. The courts has to read plain language of statute. The court has to consider.
This is worse than his alibi.
The
You
very
guys are
least,
great tonight.
California knew what it was up to, and that even if the people who wrote our Constitution didn't know what was going on, it doesn't
Bing,
mean
bing,
that the
bong,
people
bong,
who
bing, bing,
wrote the Idaho Revised Statutes in 1887 didn't
Bing,
know what they
bing,
were signing
bong,
on
bong,
for.
bing, bing, bing.
And whether or not they were sitting at the Constitutional Convention for
Bing,
something
bing,
that I
bong, bong, bing, bing, bing.
put enough effort into to figure that one out, but I don't think it necessarily.
Had your kids, had your wife.
Anyway,
Anyway,
the only other thing I wanted to touch on
Ann Taylor's skin's fucking
is how,
crawling.
by agreeing with me, the court is able to say,
He's like begging right now. By agreeing with me, he's begging. Oh my god, this is. Ann Taylor looks like she's gonna jump out of her fucking skin here.
the indictment by turning it into a presentment. As a presentment, there's a lot laxer evidentiary rules and everything else. Much of the complaints we would have about it essentially disappear, and the state has its presentment. And as far as I'm told, one of the reasons why we had a grand jury in this case is because
It reminds me of someone like when you like open the phone book and it's like the first lawyer you call because you just see like the phone book like, hey, you know, need a lawyer. You know, you just fucking call that number and this is the guy you get.
in another case, I had argued that if you don't do a grand jury, you can't have the death penalty, which I still believe.
Dead in
But
your fucking skin right
if
now.
you have a presentment, that's also listed. And so the state still gets what it wants. And we get a preliminary,
Yeah, he lost her.
which it seems to me
Yeah.
would be worth the candle for us.
I think there was some instruction about present for the grand jury, was it not? They were given that option.
Well, I think they were told about it. So I don't know. I mean, the court,
1-800 lawyer, 1-800
I
dial
can't find a
loss.
single presentment in the history of Idaho. So I don't know if they've really ever been used.
I don't know.
And I hadn't really even thought about what they are or what they meant until taking up this argument. But from what I can
Look at
tell,
Tom
going back to
like,
the
you
field code and
shitting me.
looking at everything else in the statutes that we have on hand, I mean, essentially, it's like grand jury light. Typically,
Yeah, right.
for the presentment, the idea for who is getting the presentment seems to come from the grand
Any
jury
last
members
words?
themselves.
None.
They just come in with some information about somebody, they make an accusation like it's a complaint, and then it goes off and it gets
Kohberger's
treated
like, what
more
the
like a
fuck?
complaint than it does an indictment. I don't know if the court found anything otherwise. That's the way that it appears to supposed to work. Like I said, I don't know if anybody's ever done one, but I do think that what the state accomplished in the indictment in this proceeding would easily meet the requirements for presentment. And I don't think we would have any real ability to argue with them. I mean, the grand jury itself
It
just
is
come in
fire.
and say,
Great. You guys are
here's some facts I heard from
some of
my
the funniest
neighbor, and
some of the funniest chats have been tonight. And look at, you know, we don't want to, you know, we're not trying to make fun of the situation. You know, that's not what we're doing here. We're just having a little fun. You know, I think we're pretty we pretty much know where everybody stands. So, you know, we can poke a little fun back. There's the tons of the pro Kohberger people. So fuck them. You know what? We can have our fun too. But all right, let's keep playing here. Ann Taylor just wants to fucking crawl into that table right now.
I think that guy committed a crime, and that's enough to start the wheels of justice. And I'm relatively certain we've met that requirement. And so if the court does that, then the state still has a piece of paper that says the death penalty can be sought in the Fifth Amendment of the United States Constitution. And a preliminary hearing would be offered to give us the ability to take a closer look at this case than what was given at the actual grand jury. So, you know, everybody then.
Yeah, right.
Does the court have any?
He's probably sitting like, I'm gonna fucking kill you too, motherfucker. I'm gonna get you too. In the end of all this, I'm getting you too. Look at him looking at him. He's like, I'm gonna fucking get you, motherfucker. And he's probably so mad at Ann Taylor right now. He's like, this is the crap that you're gonna throw up there. Look at Judge. He's just like, dude, let's get this over with, bro.
Questions? It looks like you might.
DK, I'm gonna get you too,
I
motherfucker.
might, on your reply.
Okay.
Nope.
Let's see.
That's it.
Thank you. Mr. Nye?
Thank you, Your Honor. As much as I enjoy the frolic through legislative history, the trial attorney usually have a shortcut, and that is to check to see
Bing,
if
bing,
it has
bong,
Supreme
bong,
Court
bing,
ruled
bing,
on the
bing.
issue. And in this case, it has multiple times. So in Edmondson, the Supreme Court said, and I
Yeah, you're
quote,
next.
the purpose of the grand jury proceeding is to determine whether sufficient probable cause exists
Yeah,
to bind the
100%.
defendant over for trial. The determination of guilt or innocence is
You guys are
safe for
great
later.
tonight. Look at the
As
chat.
long as the
So
grand
good.
jury has received legally sufficient evidence, which in and of itself supports the finding of probable cause, it is not for an appellate court to set aside the indictment. This court is bound by that holding. The Idaho Supreme Court applied that holding in two subsequent cases, Martinez and Jones, both cited in my brief. The Court of Appeals has applied that holding repeatedly. This court is also bound by its holdings. The only other thing I would add is, to summarize Mr. Robinson's arguments, Idaho law supports it as long as
Had
you
your
ignore the
kids,
Idaho Supreme
had
Court.
your wife.
California law supports it as long as you ignore the California Supreme Court. Idaho's constitutional history supports it as long as you ignore the founding fathers. I could go on, but there's nothing to see here. The Idaho Supreme Court has ruled on this, and this court is not right. Unless the court has any questions, I'll respond.
Thank you, Mr. Nye.
Thank you.
Okay, Mr. Logston, you want to add anything else?
And Taylor writing a note. We just fucking lost.
Well, that's
Imagine that.
happened. I mean, Judge, courts say things all the time.
Oh god.
Call it dicta. When a court is listing off,
Sometimes we call it the law.
sometimes,
Oh,
But-
dude, he's getting smacked around,
what
bro.
we're talking about when we talk about Edmonds, is we're talking about it. I mean, nobody was arguing in that case.
You know what this guy sounds like? He sounds like the guy, like when you go out and you're at a bar and there might be like a girl there and a group of guys, or just the guy, you know, he's like the guy that's alone and there's a bunch of people at the bar and he's talking to the girl like, hey, you know, if you go out with me, you're gonna have a good time. So why don't you just give me your number and we'll go hang out and I will prove to you that we're gonna have a good time. You know what I mean? Like he reminds me of someone like that, like trying to pick up a chick at like a bar. Like, hey, you know, I can take you out. I will show you a good time. You know what I'm saying, right? Doesn't he kind of sound like that? Like that guy? He's that guy at the bar,
The probable cause was the standard.
right? I'm right, right?
They were arguing over whether or not it's fair that some people get a prelim and some people get a grand jury. That's what that argument was about. And the guy didn't come in and say, oh no, I got a grand jury and the standard is beyond a reasonable doubt, but that's too, I don't like that. I'd rather have a prelim with a probable cause standard. That doesn't occur in that case for various, I'm sure, fantastic reasons. And the same thing happens in these later cases. I mean, it gets responded to. And yeah, the Supreme Court adopted a rule, but it's never tested the constitutionality of its own rule. It's never heard arguments on any of these
He's
things.
pissed.
It's not stating a holding after.
He's gonna get that guy.
What it's doing is it's just reviewing what it believes the law to be, but nobody's picking a fight about it. I'm picking a fight about it. And
You may have.
You know, if you get this mattress right here, you'll never have to get one ever again. I promise you that. Or like a vacuum cleaner salesman, you know, with this vacuum, the Kirby vacuum, you will never have to buy another vacuum ever again. And I'm going to tell you why.
the opportunity to do that to this.
DK sharpen his fucking shank under the dress,
Well,
under the desk.
I mean, that's what you're
And
building.
if
That's
that's-
what you're building for.
if
Because
that's-
you know that I am constrained by existing law. I can't just change the law as a trial court if it's established. And I would say that in Edmondson, there wasn't an argument because it was settled law. I mean, I think that's really the problem. So, of course, a lot happened from, 1880, 1890 to now. But the law doesn't
Bing, bing,
always
bong,
just
bong,
sit
bing,
still.
bing,
I mean, it evolves. And that may be just what happened naturally. I don't agree that the language of the statute is completely clear too. I mean, I think you can interpret it different ways, and a lot of people have interpreted that language different ways. Whether it's beyond a reasonable doubt or a probable cause. And you can argue with me about that. I mean, I'm kind of baiting you about that. So
Judge, the cases that say that are very self-serving. These are courts that are essentially openly hostile to the idea of using beyond a reasonable doubt standard. And so they make claims like to warrant really means to permit the trial jury to see it. That's not the wording of the statute. The California
Look at
case
Tom
gets
to me,
written
what the fuck?
in the backdrop of a statute being passed in the 1940s that says probable cause is what you're going to look at when you're deciding whether or not these indictments should stand. So it really doesn't.
We got to get to 100 likes.
Whether or not
We haven't
the
done
grand jury
that.
is being
Smash
told
that like
something
button.
else to some
Please
extent
smash
than
that like button.
The
Important.
I mean, the reality is
Smash that like button. We got to get to 100
just
likes.
because the courts didn't like what the legislature did up. And in our case,
William,
unlike
100 likes
California,
away. Let's
unlike
smash
New
that
York,
like button.
but what was part of the concept of due process in our Constitution was written. Just because the Supreme Court doesn't like it, doesn't mean it's somehow settled law because it refuses to follow it. It has to actually have a case and determine it. Now, occasionally, they can pass rules like they did, and so that's where this whole question of whether or not this is a substantive right and a procedural right. But they never ruled on it. And Your Honor has the ability to look at the whole mess, the totality, and say, what is the law? What was the law in 1890?
What's the name of this attorney? I forget his name because he's just rambling too
bing,
much, but
bing,
we'll give him a
bong,
bing,
bong,
bing,
bing,
bong.
bing, bing.
What's the name of this attorney? Can you post it in the chat? I forget his name. I got something funny. I'm gonna type in the chat. What is his name? Lawson. That's right, Lawson. God, he's got law in his name. Here we go. Watch my chat. Ready? Read that. Tell me what movie that's from. Read that. Remember that? Mr. Lawson, what you just said is one of the most insanely idiotic things I've ever heard. At no point in your rambling, incoherent response have you ever close to making anything considerable irrational thought. Everyone in this room is now dumber for having listened to it. What's that? What's the movie that from? Anybody know what movie it's from?
And when did it change?
Not Dumb and
I don't
Dumber.
think what the court can write is an opinion that says,
A little older than
well,
that.
we don't know when or how it changed.
Or maybe around
By
that time.
1890,
Not My Cousin Vinny.
clearly the probable cause. was
Yes.
decided.
May God have mercy on your soul. AZ knows it.
There has to be something where the Supreme Court considers
Nope.
these things in order for it to be settled law in a way that
You
when
can't
the
remember
court,
the tip of
Your
my
Honor would
tongue.
be right and
Let
say,
you
I
guys-
can't do anything about it.
Nope, it's not. That
They've never
cool.
settled this question because nobody ever brought it up.
Not Laura's Law.
Because it's really hard to get a copy of the field
Oh,
code in 1913. Well,
Yes,
I don't know.
we got it.
But
it was, well, there was I can't remember the name right at the moment, but in the 1950s, it was dicta, where the judge, the appellate judge said, no, that's not the standard because they were using beyond a reasonable doubt in that case. But anyway, there was a discussion in that case about what the standard of proof is or should be in the grand jury. So there have been touches of that along the way, I think. But you're right, there's not a whole lot of law until maybe Edmondson that was pretty clear. And then I pointed out a couple of decisions after that. With that case, I think it was 1987, something like that. So,
Bing, bing, bong, bong, bing, bing, bing.
yeah, I mean, I appreciate your argument. I mean, it's interesting. I'm constrained by the law, though. Back to that. You're making your record. That's good.
Judge. Having the decision held some things, it's true, but nobody was arguing about that standard of proof. The fact that they stated while they're walking through what a grand jury is versus what a preliminary hearing is, if that doesn't settle what the standard is. Just because they said it doesn't make it the law. I think their jurisdiction is limited, and yet broader than the United States Supreme Court. Although if you read that most recent opinion where Judge Stegner doesn't agree with any of them about what their jurisdiction is like, it gets kind of complicated. But the point is, they can't just say in an opinion where nobody is arguing.
Laughing.
Oh, and by the way, the law of the land is this. Nobody briefed this issue in essence. Nobody briefed it in any of the cases that came after it. They didn't set in stone via that opinion what the standard is. They tried by adopting the rule. The rule is the question. The court has to try to figure out.
Look at it. He's laughing.
A procedural right or a substantive right. If the court says it's a procedural right, and essentially what the court is saying is that the courts get to decide how much it takes for one of us to be thrown in the lockup, put to death, etc. Which I can't find any case
That's a
that
good
has
one.
ever
Claire.
said that.
Good one.
All said
I
that
like
the standards being set by the Constitution or the legislature, setting these standards over and over and over again. So for the Idaho Supreme Court to issue a rule setting the standard of proof, even though there is a statute that says otherwise,
Big K is
They
going to
can't do
shank
that.
that dude. He wants to
that
get
didn't
him.
become something that, I mean, they did it, but the court is in a position to consider whether or not they could do it. The court can tell the Idaho Supreme Court this rule isn't constitutional. Courts can do that. I mean, we consider bail issues. We consider bail on appeal, things like that. Statute versus procedural rights. Those things occur. And the lower court can look at that like anybody else can. Who's in the right? Is it the legislature or is it the court? So I think the court can decide all these things. But if the court's going to say, okay, I hope you'll at least write 32-page order in which you explain how right I am about everything except that.
I'll work on that. Thank you.
He's like, sit down, dude.
I appreciate the argument. I think it's really creative. And
That's something like your fifth grade teacher says to you. I appreciate the argument. It was creative. Oh, boy.
appreciate the journey back through history. I think it is an important
Smash,
factor
smash,
in determining
smash.
what the law is and why the law was established the way it was. But even you, okay, and I've heard this, but even in your brief, and this is your quote, okay, that the whole of modern jurisprudence on the issue is against it, as well as the least one founding father of this state. So I get it. I mean, what it comes down to me is that I am constrained by what I believe is settled law in Idaho. I may be wrong, but this is
That was fucking Ann Taylor leaving the courtroom right now. She ran out of there. There's Ann Taylor. Ready? Here's Ann Taylor. Kohberger's like this.
Get to the chopper!
this is certainly an issue that you would have to bring up with a higher court, like the Idaho Supreme Court, and I look forward to getting that from your perspective settled in Idaho. We'll see.
Steven!
There's the rule, of course, which is we've talked about.
And you get a sticker, and you get a sticker, and you get a sticker, and you get a sticker. That's what he's doing right now.
But this argument really is fighting against some case law too. You may say that it's all dicta. I mean, that's debatable, I suppose.
I think the whole chat's on fire.
But the Idaho criminal rules, specifically Rule 6.5A, expressly states that probable cause is the standard, not beyond a reasonable doubt. And
I think Ann
for
Taylor
grand
just
jury
left.
indictment.
Left the courtroom.
And I think I have 3 or 4 recent, because this argument has been circulating in the state. I think I've had 3 or 4 district judge decisions denying the motion. So I am going to deny that argument. I think the argument is good, but I can't go that far. Not today. I'll give you a written decision. I can't guarantee it's going to be 32 pages. It might be longer. It might be shorter. So we'll see. But it's always enjoyable to have an argument with you, Mr.
Excellent day for the state. Excellent day for the state. That's it. No more shenanigans. Ain't gonna hear any more of this shit. That's it. It's over. Thompson is confident. Look at him. He is confident. That is a huge win for the state.
So,
Taylor wants to fucking leave. Look at her. She wants out. Watch her try to get up. Watch.
with you, Mr.
No more ballyhoo. I forgot to say ballyhoo. Ballyhoo.
So,
Look at Taylor. Look.
I
Oh,
think
she wants to go.
that's all we have to do.
She's like,
still. Ms. Taylor?
Today, Your Honor.
Okay, and Mr. Thompson?
oh, let's go back in here. I'm sorry about that. Let's go back. Look at Taylor. She wants to run.
Enjoyable to have an argument with you, Mr. Longston. So, I think that's all we have to do still. Ms. Taylor?
That's it for today, Your Honor.
Okay, and Mr. Thompson?
Yes, sir. We're done for today.
Okay, nothing else to address then. Okay, well, I hope you all got a touch of Idaho history and the law and how it works, and our Idaho and United States Constitution. So go out and learn some more. Okay, thank you all. We're adjourned.
He just stuck it in even deeper at the end. He just twisted. He did a He did a fatality at the end. Oh, boy. That was good. By far, I think that was the best hearing. The best hearing. Wow. He just finished him. Finished him. If I had to echo, finish him. He ultimately did a fatality move at the end. Judge, not putting up the shit anymore. Done with it. Over. It's over. So I'm just curious now, when we'll hear a trial date. I wonder if that will come up soon. You know, will he schedule the trial and start getting it on? Let's get it on. All right. Well, we got through the hearing. Let's go do some after show. If you want to join the after show, the link is up there above. Members only after show. If you're not a current member, you want to still hang out and join the fun, you down there, hit the join button down below. It's only $1.99 to come hang out on the members only show and hang out with us. And we're going to let our hair down. Of course, not mine, but we'll let our hair down and hang out a little bit on the after show. I'm going to wrap this one up. Click on the link up above. I'll meet everybody over there on the after show, and I'll drop it in the chat. Bang. Click on that link, become a member. $1.99 supports the channel. Much appreciated. And if you want to contribute more, you can do that as well. Contribute that. All right, I'm going to lock this one up. We'll go over to the after show and hang out. See you in a minute. Thanks for hanging out. It was a lot of fun. It was a lot of fun today. See you in a minute. Bye.